Dear colleagues, good morning. UCMC starts at work today, and I invite to the microphone Mr. Scott Martin, Managing Partner of the Jersey International, on topic of the briefing the published report on the investigation of the accident flight MH17 and its implications in terms of the international humanitarian law.
Good morning, everybody. As was already said, my name is Scott Martin. I'm Managing Partner at Global Rights Compliance. We're a team of legal advisors based out of London and also working now here in Kiev. We work in Ukraine on matters relating to international humanitarian law or the law of armed conflict. Today I want to address the recent report into the downing of the MH17 and then the likely venue of where this case will next be prosecuted. If we could turn this slide, yes. Firstly, the report. The report by the Dutch Safety Board principally found that the crash of Malaysia Airlines Flight 17 was caused by the impact of a missile fired from a Buk surface-to-air missile system. The report concluded that it was a Buk missile system because of the following: a recorded sound peak, the damage pattern on the wreckage caused by the blast and the impact of fragments, injuries of the crew members in the cockpit, an analysis of the in-flight breakup of the airplane, an analysis of explosive residues, and the size and distinct bow tie shape of some of the fragments. The significance of this conclusion is that the manufacturer of the Buk missile system is located in Russia, thereby pointing, to a degree, to Russian involvement in the conflict. The report also confirmed that nearly 300 passengers were instantly killed in the blast from the missile. Further, the report found that the missile was fired from an area of about 320 square kilometers in eastern Ukraine. Further investigations would be necessary for greater accuracy. These were some of the principal conclusions reached by the Dutch Safety Board. So, what did the report not say? Even though the report described a criminal act, no criminal findings were made. The report did not identify individuals responsible for the downing of the aircraft. It did not find any Russian involvement, whether from a government or military official, and that they didn't provide the missile system to the separatists in Ukraine, eastern Ukraine. The report did not find that the Russian Federation trained the separatists in the use of this type of weapon system. And finally, it did not find that the Russian Federation ordered the downing of the civilian aircraft. Even though the report never set out to address these questions, the Russian Federation disagreed with the investigation's conclusions. Instead, it published its own findings through a report produced by MH17, the manufacturer of the Buk missile system. Among other conclusions, the MH17 report noted that if it was a Buk missile that hit the plane, it was of a missile type that only the Ukrainian armed forces use, thereby pointing to involvement by the Ukrainian armed forces. In its critique of the Dutch-led inquiry, the Russian Federation has had and continues to have concerns with their investigation into the crash. Principal amongst their concerns is that the investigation lacks the requisite independence and impartiality. For example, the board's partiality was demonstrated by the fact that it, according to Russia, ignored a comprehensive dossier of information presented by the Russians to the board. So in light of this report, what happens next? In short, we await the next report led by the Netherlands, which is a criminal investigation into those responsible for the downing of the civilian aircraft. There will be many challenges in producing this report. Chief amongst them will be the fact that it may be difficult to access certain witnesses, as well as obtaining certain physical and documentary evidence that will assist it in its investigation. Of course, this can be facilitated by the full prosecution of all nations. In furtherance of this, political pressure is already being placed upon Russia to cooperate. As yesterday, for example, Dutch Prime Minister Mark Rutte urged Russia to cooperate with the investigation. The report on the attribution of criminal responsibility is anticipated to be due out on or around February 2016. While this criminal investigation is ongoing, it's useful to consider briefly the possible locations where the case will be prosecuted. The first option is the most obvious. Prosecute the case in the territory where the alleged crime occurred. And that, of course, is here in Ukraine. There are obvious practical advantages to this approach. Firstly, the physical and documentary evidence would be easier to obtain because the court is located in the same location as where the crime occurred. It's common sense. Also, witnesses to the crime are most likely to be located in Ukraine, not any other country. Secondly, Ukraine might be the appropriate venue for prosecuting this matter, because this is the traditional approach, prosecuting individuals in the physical territory where an alleged crime is committed. Those are the advantages. Now the disadvantages. This includes that the proceedings, if they were held in Ukraine, would likely be overrun by a perceived lack of impartiality. The politics involved in the creation of a court of this type would be exploited by certain states, in particular Russia, ignoring or minimizing a very real need for accountability. In short, the inevitable and unavoidable political realities would likely overshadow furthering justice. Option number 2 is the creation of the International Criminal Tribunal for Malaysia Airlines flight MH17. On 29th July of this year, certain members of the UN Security Council proposed a resolution calling for the creation of what they titled the International Criminal Tribunal for Malaysia Airlines flight MH17 to investigate, prosecute, and, if necessary, punish those responsible for the downing of the aircraft. When this resolution was under consideration, nearly every member of the UN Security Council voted in favor of the tribunal. However, the Russian Federation vetoed this proposal, a perk of membership held by those permanent members of the UN Security Council. It was the only state to oppose the creation of the court. In terms of possible venues for this case and this attack to be prosecuted, there's not much need to spend any more time on this possible option, as the Russian government will likely always avail itself of this veto power. The third option is the International Criminal Court, or ICC, or sometimes called the Hague Tribunal, acquiring jurisdiction over the incident. This has already happened. On 8th September of 2015, the government of Ukraine submitted its second declaration to the ICC to declare that it accepts the jurisdiction of the court with respect to crimes committed after 20 February 2014. This would include, of course, consideration of the shooting down of the Malaysian Airlines aircraft. However, and in general, a case will not be considered by the ICC if it has been or is being investigated or prosecuted by a state with jurisdiction. A case will only be considered for prosecution by the ICC if the investigating or prosecuting state is unwilling or unable to genuinely carry out the investigation or prosecution. In this case, I believe it is unlikely that the Office of the Prosecutor of the ICC would find that any of the states involved, including Ukraine, is unwilling or unable to investigate and perhaps ultimately prosecute those involved. The Dutch Safety Board, in cooperation with many states, has already conducted and provided a report on one step of its investigation. It has indicated that it will be taking the next steps in the investigation by attributing responsibility for the downing of the aircraft. The final option, and the most likely option that I'd like to consider, is the creation of a multinational agreement that binds together each state that has a jurisdictional claim to prosecute jointly those responsible for the downing of this aircraft. After the investigation by the Dutch concludes, a tribunal could be set up. It would be relying upon the same statute that was proposed and subsequently vetoed by the Russian Federation at the UN Security Council. The only difference here is that it does not require Security Council backing. Essentially, this is a pooling of jurisdictions of all the states that have the right to prosecute. This would include, of course, Ukraine, the Netherlands, Malaysia, and any other country where one of their citizens or nationals lost their life. In short, instead of claiming the right to prosecute in their own state, each state acknowledges overlapping rights and has agreed to forego these claims and instead create a new tribunal in the Netherlands. Finally and lastly, the question that many ask when discussing the creation of a tribunal in this context invariably relates to whether individuals from Russia could be charged with a related crime. And if so, what could that crime be? This is a difficult question to answer at this point. Until the criminal investigation is concluded by the Netherlands and its partners, the exact parameters of potential culpability for the Russian government or government officials is unclear. It would be irresponsible to come to any premature final conclusions. Here is what we know, or at least what's been made public thus far. Firstly, and again, the Dutch Safety Board reported that the missile system used by the Buk, that the missile system used was the Buk missile system, and it was Russian-made. Secondly, certain Russian military actors appear to have been closely involved with separatist actions around the time that the plane was shot down. For example, there are phone intercepts that appear to show Russian military officials were speaking to separatists before and after the aircraft was shot down. These intercepts include the following. Firstly, one of the separatist commanders in Ukraine named Igor Bezler contacted Colonel Vasily Zharanin, allegedly of Russian military intelligence, confirming the downing of the aircraft. There's another intercepted phone conversation between a so-called deputy minister of Defense of the Luhansk People's Republic, an individual and an individual named Orayan, identified also as a Russian military intelligence officer. In this phone call, the deputy minister indicated that military planes from Ukraine would be in danger as they have a Buk, or the Buk missile system now. Finally, there appears to be a 17 July conversation between two commanders in Donetsk discussing that the Buk missile system came through from Russia. This appears to show involvement. However, it may or may not show involvement yet in criminal activity. It is crucially important to note that one should not come to conclusions such as these before a criminal investigation is concluded. This is the finish of my presentation. I'm happy to take questions if anybody has any.
Thank you, Mr. Scott. Let's ask some questions here, please.
Natalie Polenko, UCMC. Well, my first question is, if such multilateral agreement is signed and the tribunal is set up, we all know that Russia will probably call it impartial and will not cooperate. And what can this tribunal actually do with Russia? If they find some Russians are guilty, how can they execute the finding, the judgment, if Russia doesn't cooperate?
It's a very good question, and it highlights one deficiency, sadly, in the international community and international criminal justice. And if your suspicion is correct and there's a wholesale lack of cooperation, it highlights this problem, and that is so many situations without enforceable systems of international law in place require international comity cooperation. They require, if there is an arrest warrant issued, for the state enforcement bodies to enforce that warrant for the arrest and enforce their presence. In all likelihood, at the moment, and things could change, but in all likelihood, if this court goes forward as anticipated and has placed itself in The Hague, and it will find it difficult to obtain cooperation from the Russian Federation, if indeed the Russian Federation is involved. And there are only really political and diplomatic levers that you're able to push to try and compel cooperation. There are certain legal mechanisms involved. It would depend on a number of circumstances, but there are legal agreements on jurisdiction, such as the Montreal Convention, that could mandate one or the other actions, that you extradite the individual or you prosecute them domestically. But that has, without getting too much into complexities, has a lot of complications at the end, because it ultimately can be challenged in the UN Security Council, where Russia also holds a lot of power. So that's a very long answer, but it's also, I think, a critical question. The case may go forward, trying them in absentia. There are certainly some human rights implications with that type of approach. If you look at treaties such as the ICCPR, for example, and their fair trial right guarantees. But at the moment, it's difficult to tell. Perhaps there will be cooperation, and if not, I suppose the tribunal will contemplate in absentia proceedings.
And my second question is very different.
Okay.
About that Ukraine had to close.
Ще одне запитання про те, що Україна закрила свій простір після цього інциденту. і країна відповідальна за свій простір. І зараз Нідерланди говорять, що ми повинні це зробити, але про це не говориться тобто, які будуть наслідки для України, які можуть бути технічні наслідки внаслідок цього. Ну, на жаль, я спеціаліст у гуманітарному міжнародному законодавстві, і я не можу відповісти, що повинно коїтися, що не повинно бути. Я знаю, що також там був якийсь паралельна доповідь, що є багато інших літаків у той день в таких же ситуаціях. Тобто я не можу це предугадати. Але що стосується цього трибунала і якоїсь кримінальної відповідальності, я б відповів, що моя перша реакція – це категорично ні. Дякую, містер Скотт. Можна я задам вам ще одне запитання? Можливо, це буде дуже просте запитання, але кожен українець про це думає. Ми ж думаємо про те, росіяни, вони винні або не винні. Що ви думаєте? Чи винні росіяни у цій катастрофі MH17? І думаєте, що є можливість, що російський президента можна посадити за ґрати за цей інцидент? Просте запитання говорите, просте, але провокативне. Я вважаю, що я вважаю якимись теоретичними перспективами, про це повинні говорити Нідерланди та команда тих, хто розслідує цей злочин у лютому. Але у цій краткій презентації можна було знайти вже можливі проблеми, які ведуть до військового становища також. Тобто я вважаю, я можу сказати тільки, що ми можемо почекати і побачити, але ми всі повинні дочекатися лютого, коли це буде більш стосовним. Але я вірю, що комісія працює, але ці запитання, вони дуже складні. І вони складні на цілі низькі рівні. Це дуже важливо, це дуже важкі запитання, я повторюю. І от той трибунал, про який я зараз вам розповідав, і можливо, що це на ньому коїться. Але як я помітив, багато судів, вони ввели нові інструменти для чинства, але це дуже залежить від співпраці. І оце та зона, де я бачу, будуть проблеми з Росією. Більше немає запитань. Дуже дякуємо, містер Скотт. Ми будемо дуже раді бачити вас тут у лютому. Дякую, я буду дуже радий прийти.
Прес-брифінг об 11 годині.
Dear colleagues, our next press briefing will be at 11. Фух. Да, конечно. Как будет отчет?
Звіт.
А воздушное пространство?
Простір повітряний.